did everybody pick up one of those forms? I printed you basically what you would get off of the Attorney General's website. So, did you get one?
I
of those?
didn't. Great, thanks.
Yeah. So look at the back of it there. Yeah, just a signature and says you must date and sign this. So that's all the formality that's required. Like you said, you don't even need to have it notarized. Now, yeah.
So like for my mom, no computer, no anything at her house, can I register for her? So that she could, because we did hers a number of years ago, but obviously didn't get a card in the mail or anything, it was just the.
If you did it a number of years ago, I'd update it.
Okay.
There's been some changes to these things. I think it's a wise idea to update it. And I'm going to tell you, with all of your estate planning documents and stuff, choose a day. I don't care whether it's your birthday, your anniversary, January 1st, whatever it is. Choose a day and really try to go look at these things and just look at them and say, does this still make sense? Is my condition still the same? You know, it's the last thing that anybody wants to do. And let me tell you, it's one of those things that you'll put off unless you just put it on your calendar, pull it out. Honestly, it'll only just take a few minutes just to make sure this still makes sense to me. But a lot of these forms have changed, and let me tell you the reason. It's not so much that I think that the substance is that much different, but the people that look at these, that rely upon them, like to see the form that they're familiar with, and they'll give it more credence if they do. If they see some, handwritten form or some old form or something, now they start questioning, is this, can we really rely on this? So I think it's just a good idea to update that. You can go, you can download it, you can print it. I'll give, if you just call me, I'll give you the details about where to send it and stuff. But I actually think it's on the Attorney General's website. You'll just click and they'll tell you exactly how to register it and stuff. So let's say you don't have a durable power of attorney for health care. It doesn't mean that you don't have any recourse whatsoever. That's part of the power that of the legislation that was passed. So the first thing is you get to always, as long as you can communicate, and as long as you're competent, you can make your own choices. And I don't care if you just fill out a living will, you can revoke that living will just like that. If you decide, and who knows, I mean, I fortunately haven't been at the edge of death yet, but when you get there, maybe suddenly you have a revelation that I don't want to have anybody withholding medical treatment. So you can revoke it right then, as long as you can communicate. This comes into play when you can no longer communicate. So let's say that you haven't done anything. So we have a statute, and it says this is the priority that we're going to give. First person that has the right to direct your health care decisions is your legal guardian. Sometimes people have had a stroke or have had some sort of a medical condition. They're no longer competent. They've had a guardian appointed. So if that person is a guardian, they've got a document that appoints them as the guardian. They can show that to the hospital. They'll follow that. The person named in the living will, okay? That, or the durable power of attorney for health care. That person can make those decisions. If you don't have any of it, then it's your spouse if you're married, and the spouse is competent. A parent of the patient is next. Any relative representing himself or herself to be an appropriate, responsible person to act under the circumstances. And go to the next one. Any other competent individual representing himself or herself to be responsible for the health care of such person. So this is why I recommend that you name the person. those are pretty open-ended things. I gotta tell you, I don't think many hospitals are just gonna let a guy come in off the street and say, hey, I know this person. In fact, I just saw something in the paper this morning about somebody that could no longer do things for somebody that was at the hospital. So, it's still, it all depends on your circumstances. If everybody in your family is invested in the welfare of you and the other members of your family, you probably don't have any problem here, but that's not every family. I mean, I've seen a whole lot of families that are very dysfunctional, and you certainly wouldn't want this person making your decisions. So that's why, execute it, and then you don't have to worry about those things. And then there are some special rules for medical emergencies, and that frankly involves, even if you have a living will or something, you come into an emergency room, you can't communicate, there's a medical provider that's gonna make decisions for you until, things sort out. Okay, already talked about the alternates and stuff. So we've talked about living wills and healthcare power of attorneys. You can look through that form. You'll see that it's quite involved. I think, what is this, about a 6 or 7 page form. There is one provision that I think that you ought to think about. It's the statement of desires, special provisions and limitations. There's a great big blank on about the 5th page of the document. There's 7 pages on this, where you can write some things in. I mean, I'm not talking about necessarily things involving whether they withhold hydration or nutrition or things like that. Maybe you want some directions about, do you want to be cremated? Do you not want to be cremated? What mortuary do you want? Those are the sorts of things that you can put in there. Those are the sorts of things that we don't like to talk about and we don't like to think about. But, if you do, that's the place to write some of those things so that your loved ones and, the people that are going to be responsible at that point know what to do, know what your desires are. I've only had one case where there was a fight over where the funeral was going to be held and who the mortician was and stuff. It's not pleasant at that point. The deceased doesn't have any say in it, but it isn't pleasant for the family. So, if some of those things can be discussed in advance, then I think that's good. All right, so questions about all of that? Beat that horse to death enough, you think? So, okay. So I thought, at this point, that maybe, that's the website for the AG, but frankly, it's easier just to Google the thing rather than that. But it's actually in that handout. I'm going to give you a handout that it's in. So let's talk a little bit about estate planning. And I can't get into great detail about this, but I think, if we're talking about these things, let's talk about a few of the little lighter things, if you will, about end of life, and that is your will, trust. Let me talk about one thing first that I think I have another bullet point on it, but rather than just a will or a trust, the next thing that you need, which is something I recommend all of you, go out and get it right away. And you do need to update this form because these forms have gone through some changes in the past few years. I think they've been relatively stable for maybe 3 years or something like that. But again, banks and financial institutions, they tend to have more or less questions if it's the current form that they're familiar with that's laid out in the statute. And that's a financial power of attorney. Financial power of attorney. And these are very, very powerful documents, so I want you to understand how powerful it is. What you basically are doing by giving somebody your financial power of attorney is you're giving them the authority to do every single financial transaction that you could do for yourself. With that document, they could go out and sell your house, clean out your bank account, do everything. And listen, the bank's not gonna question it. If you've got a valid power of attorney, they're going to do it. Now, I mean, if it's weird circumstances, they might, call somebody. But basically, that power of attorney gives them the authority to do that. It can be really complicated. You can make it really complicated. There are such things as springing powers of attorney. Springing powers of attorney mean that it doesn't go into effect until certain circumstances have occurred. And most times those are that some medical professional has determined that you are incompetent or incapable of acting for yourself. Well, in the right circumstances where you don't have a trusted loved one to give your financial power of attorney, that's an alternative. I think what people need to understand is we can make these things as complicated or as simple as you want. If you've got a special circumstance, you need to communicate that to your lawyer, and they can figure out how to do it so that it fits your circumstances. Some people think, well, it's only if I do that I have to hold on to it, things like that. No. If you think you have to hold on to your power of attorney, you gave the wrong person the power. Or you didn't put the right conditions in your power of attorney. This has to be somebody you totally trust with everything. But it is absolutely necessary because this is what's going to happen. If you don't have a spouse and you haven't made some of these decisions and you stroke out and you can't make decisions and you can't do these things, somebody's going to have to go to court and they're going to have a guardian and a conservator appointed for you. It's not an impossible situation, but it takes about 6 weeks to do it because the court has to appoint a visitor, a person that's going to come and try to talk to you and discover for themselves whether or not you're competent. They're going to appoint you a lawyer. They're going to appoint a doctor to examine you, and those people have to have time to do all of that and report to the court. Sometimes the Department of Health and Welfare gets involved in it, and it can be really a complicated situation. You avoid all of that by having a financial power of attorney because there isn't any need to do those other things.
Gary, do you recommend like a single person? Like in my case, I have my 3 sons, and I think we have it designated that they will
I do.
agree,
I
but I don't think they'll agree.
I know exactly what you're talking about, Karen. It's a very valid point. I've had people come into my office. They don't want to hurt anybody's feelings.
Right.
And I totally understand that. This is a sensitive thing. I mean, they're going to find out that, hey, you gave Joe the power of attorney, you didn't me, and it may cause some problems because a power of attorney isn't any good unless you tell somebody you gave them the power of attorney, right?
Correct.
So, but here's the problem. Try to get 2 people to agree on something. 3 people even complicates it further. And these are things that generally need to be decided quickly. So, no. My recommendation, I'm not saying this is the only way to go, but my recommendation is it's one person. And now, you have alternates because sometimes that one person, who knows? I mean, maybe you and your son were in the same accident and he was killed and you're just maimed, and now you don't have an alternate on your power of attorney. So, I think alternates are very necessary on these things. Okay, so financial power of attorney, that's pretty easy. I mean, I just think that you need to do it, need to figure out who you're going to give that power to. Now, again, these things can be revoked like that. You can revoke it very quickly. Kind of the problem with revoking it is, how are you going to tell everybody that it's revoked? If you got somebody that went postal on you and they're out there doing some things with your power of attorney, how are you going to advise people that they no longer have the power to do that? I hope you never get in that situation. There's probably some things that we could think of that we could do to solve that problem. I've rarely ever had it arise, but so those are powers of attorney. Now, wills and trusts. Do you need one? Well, I don't have one. You know, I'm kind of like the shoe cobbler, right? He doesn't have shoes for his kids, so, you know, I think I have this hesitancy to even think about these things, and so, no, I haven't done it. But you're not without recourse if you don't have a will, okay? It's just kind of like the power of attorney. Now, you know, I'm leaving it up to the state to make these decisions, and fortunately, the decisions, if you have a very simple situation like I do, my wife and I have been married for 42 years or 43 years, and we have 3 kids. They're all healthy, and so the statute's going to take care of that. If I die, everything I have, and the other proviso is, I didn't have a red cent when we got married, neither did my wife, so everything we've accumulated is community property. So if I die, everything's going to her. If she dies, everything's going to me. If we both die in a common accident, it's going to be distributed equally between our 3 children. Well, that's a simple situation. Why do I need a will that says that?
Well, how about, we've been told that if, now I have a will, and I've got everything legally done, but then I read and I hear that if I don't have a trust, that it can go into probate.
Probate, I know, I mean.
And that'll take a long time, and
My dad is 102 years old, and that's all I hear from him is, it's going to go into probate. And I go, Dad, I'm a lawyer.
Yeah.
I can handle probate, okay? It's not going to cost anybody a red cent because I'm a lawyer, okay? So I totally understand that. And people, I'll tell you, they have caused this fear among people that things are going to go into probate.
Okay.
Probate's not scary. It's not. All that happens, it's just a procedure. It's just a procedure that gives the court a little bit of authority, and they designate who the personal representative is, and now they give them the authority to transfer your assets to your beneficiaries. Okay?
How long does that take? Like, we had an uncle that my husband couldn't even write a check to get underwear because,
I'm not saying that there aren't some circumstances where it can be a mess.
okay.
But
As it was.
most circumstances, well, I'll give you an example. I can't give you a name, but the person called me one Sunday night. I had the probate filed on Monday, had his wife named as the personal representative, and everybody signed off on it, and everything was done within a week. Okay? Everybody was in agreement with it, okay? But just because you have a will or a trust doesn't mean that everybody's going to be in agreement with it and there isn't going to be a fight, okay? Probate, the reason that probate got a bad name is back before, just before I became a lawyer, in fact. I became a lawyer in 1975. Just prior to that, lawyers charged a % of the estate rather than their time in it. And the estates, or the wills that they had drafted became their retirement account, in effect. Because they were going to get a percentage of everybody's estate they probated. It was, you know, probably back in the day it wasn't a bad thing, but as things developed by 1960s and early 70s, it was a ripoff. And so our bar association, and I think this is true in other states, but I'm not going to get into that, but in Idaho, our bar association said that's unethical, and we stopped that practice. And so now you cannot take a percentage of somebody's estate to probate it. It's unethical for us to do it. We don't do it. So we do charge you, you know. I mean, there's a filing fee. It's nominal. Basically, all that happens in most estates is it's all handled. You don't go to court. It's all handled out of court. You name your personal representative, or there's a priority list. It'd be your spouse, it'd be your children, your parents, etc., in that order, to be named as the personal representative. They're given authority to gather all of your assets and distribute them. If you don't have a will, it goes to the people that would be in line. It'd be your kids. Okay? If you don't have a spouse or you don't have kids, it even tells who gets it in that circumstance. So, you know, they just distribute it as necessary, and they file a final accounting with the court, and it's done. So it's not a scary thing to do, but I'll totally agree with you. And I think, well, in fact, if you go on the Attorney General's website, you will find out that what they call living trusts is probably one of the most abused legal documents, and many people have been defrauded with these things.
Okay.
And if somebody calls you up, or you go to the Senior Citizen Center and they're pitching
Yeah.
a living will, or I mean a living trust, approach it with caution. I'm not going to tell you that they're wrong or that everybody that does it defrauds people. I'm going to tell you that it has happened many, many times, that they've overcharged for that and they've defrauded a lot of people out of it. Okay? So let me tell you what a will and a trust is about. Okay? Why do you need a will? Okay? I just told you, I don't need a will. Now, some people would probably argue with me, but I want you to understand, it isn't scary that you don't have a will, but what are you going to try to accomplish with a will? What's your purpose? That's the thing that you have to think about before you go into the lawyer's office, because that's what he's going to ask you. But what are you trying to accomplish? Why do you need a will? That's not the time to start trying to think of an answer to it. It doesn't come to most of us very quickly in the presence of a stranger as to, you know, what's my purpose here? Well, generally what our purpose is to figure out who's going to get it, okay? Now, if you are married, okay, Idaho's a community property state. Community property simply means that everything that you acquire while you're married is equal. Half your spouse and half yours. So when you die, not everything that you own is passes over with the probate or with the will. It's just the portion that you have control of, your half. So it's half of it that goes. And some people forget about that. They think, well, it's everything in the estate. Some people think, well, geez, what about taxes and things? Right now, the limit is $5 million per person. So unless you have more than $5 million that's going to go, you aren't going to have any taxes. Idaho doesn't have estate taxes, but the feds do. Okay? You can also give away an awful lot of stuff without paying any taxes whatsoever. You may have to file a return, so you may have to deal with an accountant about it, but you don't pay taxes on it. It's the same exemption. Okay? Now, you've all heard about the exemption of about $13,000 a year. That means I don't have to file a gift tax return. I can just give any one person I can't remember what the exact amount is, but it's like $13,000. I can give it to them without reporting it to anybody. They don't have to report it. It's a gift to them. And, you know, so some people use that as a way to reduce their estate. And some people just do it because they want some people to have some of their property while they can still use it. So it's a good tool. But what a will does is it divides your estate between those people that you want to have it. Now, a lot of times that's going to be your children, and it's going to be equal. Well, I'm saying you accomplish that same thing without ever having a will. But even if you do it, at least you have, I think, the satisfaction that I've done it. My family knows what my wishes are. And the next thing that's important about that is you have to designate somebody as your personal representative. And Karen, that comes back to this. Don't designate all three to act co, because it's just a mess. One person and have some alternates. Okay? They're simply going to gather all of your property, and they're going to figure out how to get that distributed. And sometimes that's not as simple as you might think. I mean, you know, a lot of times our home is our biggest asset. Well, how do you divide that thing up? You know, it's hard to do sometimes. So now you have to have somebody that uses a little bit of judgment. You know, do they sell it? Do they just make everybody a co-owner of it? There's you could imagine any number of ways to do it, and so you give them that power to do it. The thing that the statute doesn't do, it doesn't give any charitable gifts. So if in your mind you'd like to give some things to the church or something like that, if you don't have a will, there isn't any directive that happens unless you've made some advance changes. Now, 10 minutes? I've used that much time already?
You only have 10 minutes left.
Excuse me, Gary,
Yes.
is executor the same as
It
representative?
is, yes. Yeah, most people have heard the word executor. We call it personal representative. It's exactly the same thing. What was I gonna say? Something about, yeah.
You're talking about
Charitable
charitable.
donations.
Oh, yeah, charitable donations and stuff. So, that's a perfect place to put in a will, that you want a certain amount of it to do. Now, people also can set up accounts. There are some very creative accounts that you can set up at the bank. Payable on death accounts, so the person that is named there gets that account upon your death. If you have a joint account that you've set up, well, when you die, that person then takes the account. We do this with our spouse and a whole lot of things. You don't do a payable on death, you just do a joint account, so when you pass away, your spouse can still use the account and stuff. That takes care of a lot of problems. Beneficiaries on life insurance policies, that doesn't go through the estate. That doesn't go through probate because you've already determined who gets it. Your bank accounts, if you designate somebody as a beneficiary of your IRA or your retirement account, any of those things, that doesn't go even through probate.
Same way with stocks and
Exactly.
investments.
Exactly,
same thing.
because probably, if you look, you may have forgotten you did it, but probably when you set up that account, you designated somebody as a beneficiary in that account. Now, I'll tell you what, people forget who they designate as beneficiaries, and sometimes you find ex-spouses on there. But, there are some rules that, change that. But my point is, take a look at some of those things. We do it, and like I said, you put it on the shelf and you never do it again. Now, so I think all of you understand wills. I want to touch on trust because this is the thing that, everybody's going to say, I need a trust because I don't want to go to probate. I hope I've already dispelled that. But there are reasons that you might want to trust. I actually think that it's more appropriate in the case of young people because particularly if you have an asset, a business, or you've got some money or something, and you've got children. What do you think is going to happen when you pass away? Your wife's going to get remarried. And now that scoundrel's going to take all of your money and he's going to do something with it that you're not going to be happy about. But, and your kids aren't going to get anything. Or you're going to give it to her children. There's a whole number of things. Well, that's kind of where trusts come into play. Okay? What you can do with a trust, and it's revocable until one of the spouses die. And I always tell people, the choices that you make with your spouse are different than you would make by yourself. I can almost guarantee you that that's the case. Once your spouse is gone, the decisions you make are different than what you would have made with your spouse. And I see this in juries all the time. 12 people will make a different decision than any one of those single people because it's a group dynamic. So you've made this decision with your spouse that this is the way I want things to go, or that I should say we, not I, we want things to go. So what you do is you put all of that in a trust. Now the one reason I don't recommend trust to a lot of people unless they have a real reason for doing it and they've thought through it is you have to put all your property in the trust. If you don't put it in the trust has no power over it. So you have to put your house